Okay, all the attendees are loaded, so we are ready to go for the hearing.
Good evening. The November 17th, 2020 Liquor Board hearing is now in session. For note, the following establishments have been settled and their fines paid, so they've been taken off the docket tonight. That's D.D. Summers, trading as Summers, Four Fish Deep, trading as Broken Ore Bar and Grill, GT Ventures, trading as Brews and Q's on the Boulevard, B&B Buildings, trading as Bank Shot Bar and Grill, and Walden Community Association, trading as Walden Country Club. So the first order of business, the board now has all meetings transcribed, which serves as minutes of the hearing. The board keeps such minutes stored electronically, and they are available to review by calling the board for an appointment. I now make a motion that the transcripts of the previous board hearing held on October the 20th, 2020 be accepted as the board minutes for that date. And I ask for a second.
Second.
All those in favor?
Aye.
Aye.
That is carried. Thank you. I'd like to turn the meeting over to our counsel, Mr. Blumenthal.
All right, thank you, Mr. Chairman. Ladies and gentlemen, any petitions or letters or exhibits that the board has received more than 5 days prior to today are automatically accepted as board evidence in any case in which they were filed. The same thing is true for all applicants and for all exhibits and papers they file. At the beginning of each hearing, I normally make several announcements. At this point in time, I'm having some technical difficulties. So while I will be listening in and serving as counsel to the board, but probably not speaking, the hearings will be administered and run by Phil Dales, who, for the purposes of all hearings this evening, will be counsel to the board. So at this time, I virtually introduce Phil Dales, and he will have a few comments to say too.
Good evening. At the beginning of every meeting, as Mr. Blumenthal said, counsel to the board makes several statements. Tonight, I'm serving as counsel to the board. Phil Dales of the law firm Lift, Walsh & Simmons, and Harry Blumenthal will be co-counsel to the board. He's counsel to the same firm. And first statement I need to read is that the commissioners are part-time public servants who have other business and social interests. And if they know that they have a conflict of interest in a matter before the board, they recuse themselves from that matter. If they don't know of any such conflict, we leave it to the public to advise in writing that a commissioner or commissioners may have a conflict of interest. If that happens, the board will rule on whether or not the commissioner or commissioners in question have such a conflict. Second, the chairman of the board, Mr. Maloney, has the ability to assign board counsel the right to rule on admissibility of evidence and objections and exhibits. He has, in fact, assigned that right to counsel, and co-counsel will rule on admissibility of evidence. In the event that there is any objection in this hearing, we will rule on objection. Our ruling will be the ruling of the board. Last, this is a virtual hearing during the COVID-19 pandemic. The board rules are published online for all to read. The public may participate in these virtual hearings, but only by written statements presented to the board prior to the board meeting. The public is invited to listen and view the hearing online, but there will be no participation other than by written statements if previously submitted. Prior to the hearings, the commissioners will have read all applications, exhibits, documentation, and statements submitted by the public related to the applications and other matters on the hearing agenda. There have been no statements submitted by the public for these hearings tonight. And with that, I'll turn it over to Chief Inspector Wayne Harris.
Thank you, Mr. Dales. Good evening, everyone. Chief Inspector Wayne Harris. Before starting and calling the first case, I'd like to remind everyone that there'll be no waiving of the readings on any of the cases. I will read them in their entirety. Also, please remember to identify yourselves before speaking. For recording purposes, it's necessary. Also, it's a good practice when you're not speaking, if you could mute your mic, that would help out also. The first case tonight is a Caliente Grill known as Super Caliente LLC. We need Irma Roxanne Rodriguez, who is a member, Inspector Danielle Kane, and Inspector Supervisor Alan Southworth. This is a Class H license with beer, wine, and liquor, with entertainment, and a Sunday license also. Located at 907 Bay Ridge Road, Annapolis, Maryland, 21403. The first violation is a violation of the alcohol beverage Title 1 through 12, the annotated Code of Maryland, Title 6, Subtitle Section 6-311B1, restriction on purchases and sales by a retail dealer, referencing the Comptroller of Maryland, Field Enforcement Bureau, case number 21-0015 by Inspector Danielle Kane and Inspector Supervisor Alan Southworth. Incident dated August 21st of 2020. The second violation of alcohol beverage 1, Title 1 through 12, annotated Code of Maryland, Title 6, Subtitle Section 6-313, A1 and 2, tampering with alcoholic beverage containers, referencing Comptroller of Maryland, Field Enforcement Bureau, case 21-0015 by Inspector Danielle Kane and Inspector Supervisor Alan Southworth. The incident dated August 21st, 2020. There is a restriction on this license, which is alcoholic beverages must be served in conjunction with meals on 3/22/17. Anyone wishing to testify for and against, we're going to ask them to be brought forth to the panel, and I'd like to be able to see you if visually possible.
Ms. Rodriguez, do you have video capability?
Good evening, everyone. I am trying, but it won't start. I'm gonna try one more time with the settings. I was afraid to lose I'm gonna try.
Ms. Rodriguez, are you representing yourself?
Yes, I am, sir.
Okay, so you're the only person here testifying then on
Yes,
behalf of
yes, I am. Yes, I am. I can I use the camera. For some reason, I'm sorry. Can I connect with my phone? I'm in a personal computer.
Can we proceed without the video?
Yes.
All right, thank you, Mr. Blumenthal. Ms. Rodriguez, we're going to proceed without the video. Please raise your right hand. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You do?
I do.
Okay, thank you. Mr. Chairman? Oh, please state your name and address, Ms. Rodriguez, for the record.
Okay. My name is Irma Roxana Rodriguez. My home address is 8 Thorn Court, Annapolis, 21403, Maryland.
Okay, thank you.
Ms. Rodriguez, you can proceed either by proffer or by testimony, and please understand you'll have half an hour to present your case.
I only can honestly say that in the middle of pandemic, we had to use anything we could to infuse our liquor that we do with jalapenos, and sadly was found in one of our bottles with the brand name, what normally we shouldn't do. But we have changed that immediately as it was indicated by the inspectors, so it will not ever happen again. And then also they found some items that were given as a gift for us from our friends that travel abroad. So all I can say that I really didn't know that those items should not be in the premises of the restaurant. I only can say that this will not ever happen again.
Okay. May I interrupt Inspector Kane? I did not swear you in and I apologize. I didn't see you on the screen.
That's okay.
Did, did you hear the oath?
I did.
Okay, and do you so swear?
I do.
Okay, thank you. I apologize, everyone.
That's okay.
Mr. Dales, do you want
Mr.
Inspector
Harris,
Kane to-
since there will be no waiving of the reading of the cases tonight, should Ms. Kane and Mr. Blumenthal, if you could advise, should Ms. Kane read the case?
Sure. So on Friday, August 21st, 2020, at approximately 11:21 a.m., Inspector Supervisor Alan Southworth and I, myself, Danielle Kane, from the Comptroller's Office, Field Enforcement Division, conducted a routine liquor inspection at Caliente Grill, located at 907 Beverage Road, Annapolis, Anne Arundel County, Maryland, 21403. Upon entering the establishment, we identified ourselves to the owner and licensee, Irma Roxana Rodriguez, and explained the purpose for our inspection. Caliente Grill holds a valid Class H BWL ENTS license number 101, issued by the Anne Arundel County Liquor Control Board. We located 4 bottles that there was no invoices for, as well as 2 that had been tampered and refilled, which she already spoke about. And those are the items that we seized at the time of the inspection.
All right. This is Harry Blumenthal. Do we have other witnesses with testimony regarding the violations?
May I speak?
Yes, please do. If the board finds that you did something that violates the code provisions, is what we call strict liability. And even though the board may have sympathy for you, nonetheless, the code mandates that the board make a finding of violations. So please tell the board every reason you can think of as to why the board ought not to find a violation in this case.
Okay, may I speak now? I'm sorry.
Certainly.
Okay. I do not recall that there were bottles, without invoices. I did everything I could to bring all our invoices and even went online to locate the invoices that were purchased. All the bottles I recall that there was one bottle specifically that was purchased, and I went online and located the invoices. I would like to really know specifically which bottles were found that I did not have invoices, because I have organized myself every invoice, and I actually brought several months out for you both to look at them.
That's good.
And I do not recall any bottles that were purchased without invoices.
The containers that I'm referring to that did not have invoices are the ones that you had already testified to as gifts that you would receive
Okay,
that
I
were on
understand.
location.
Yes, I understand that. Okay, I was worried.
That's okay.
With regard to those invoices, do you have any proof that contradicts the testimony by the inspector?
No, sir. Those were actually gifts, as I mentioned, and those were actually not in the front counter facing. They were actually hidden above the bar, but they were hidden because they were not for sale. That's the only thing I can add to the location of the bottles, because um, they were not for sale at all at any point, and they were in the counter above, not facing all the I would say the customers, not for the customers view, because they were key for us. That's only I can add.
All right, thank you. I turn the administration of the hearing back to Mr. Dales, who will turn it back to the commissioners.
Chairman Maloney, I think if you have any questions, you can begin with any questions for Mr. Rodriguez. And I think you're muted, Chairman.
Mr. Maloney, you're muted.
Chairman, you're muted, so.
All three commissioners are muted.
This is Commissioner Duffy. I have no question. Individuals have committed guilt.
I didn't hear that part of it. Is she
This is
committing?
Commissioner Duffy. I have no question. The licensee has committed guilt, so therefore I have no questions.
Okay, this is the chairman, John Maloney. Did I miss the fact that she declared that she is guilty of the infraction?
I don't think she said that, Mr. Chairman.
Then I didn't miss that. Mr. Rodriguez, how long have you been in business?
It's gonna be 8 years, sir.
1 year.
No, 8 years.
8
It's going
years.
to be 8 years.
Okay, and I guess I'm trying to figure out if this is a pattern or this is just something that for some reason 4 bottles just kind of turned up and were discovered. I mean,
No, sir. I would say that I wasn't aware, or I didn't really know that a bottle that was given as a gift should not be in the area. I would say, I would say not even in the restaurant. So I really wasn't aware of that, and this is not really a pattern because we do not. Everything that we sell is purchased by invoices.
okay, okay. No other questions.
Commissioner.
No,
Phillips, question?
I don't have any questions for the client.
But then I think this would conclude the evidentiary portion of this hearing. We can close the record for testimony.
Well, at this point, do we need a motion, Mr. Dales?
Yes.
I think that the floor is right for a motion.
Well, I'd have to say that I feel that obviously the law here was broken, and I would fine the establishment $250 and court costs, and that I'll put that in the form of a motion.
I'll second the motion.
Commissioner Duffy, I second the motion.
Okay, is there any further discussion by the commissioners?
None that I have.
Okay, seeing none, I will call the question. Those in favor?
Aye.
Aye.
Aye. Okay, the motion is carried.
Thank you, Ms. Rodriguez. Thank you, Inspector.
Thank you. Thank you.
Okay. Mr. Aronson, I'm about to call the second case, which is, this is Chief Harris. I'm calling Anchored Inn, known as Hidden Harbor Inn LLC. Ashley Hanglider, authorized person. Stephen Cooper, manager. Myself, the chief inspector, and the inspector in the case. This is a Class D license on sale for beer, wine, and liquor, entertainment, and Sunday license located at 604 Cabana Boulevard in Deal, Maryland, 20751. Violations are as follows. Violations of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.09, Public Welfare. Reference Board of License Commissioners for Anne Arundel County, violation notice number 2260, supplement report dated August 9th, 2020. Second is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct. Reference the Board of License Commissioners for Anne Anne Arundel County. Violation notice was number 2260, supplement report dated August 2020. There are restrictions on this license, and they deal with the hours of operation between 9 a.m. and 11 p.m. Outside service has been a boathouse on a seasonal basis and a fenced-in pool area with a portable bar. Anyone wishing to testify for or against, please come forward, and I will be testifying as the inspector.
If you'll raise your right hand, you solemnly declare and affirm on the penalty of perjury, testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do. My name is Wayne Harris, Chief Inspector for the Anne Arundel County Liquor Board, 2660 Riva Road, Annapolis, Maryland.
I do. My name is Ashley Hanglater. I am the authorized person of the Anchored Inn. My personal residence is 696 Rockhold View Road in Deal, Maryland.
Steve Cooper, manager. My address is 5721 Great Oak Parkway, Georgetown, Maryland.
Okay.
Chairman, you want us to identify ourselves?
Chairman Lunny, I think you're either muted still or the microphone is too far away from you.
Who's that, me?
I think Chairman Lunny was speaking and I could not hear.
I'm fine.
Right. So
Would you like me to proceed with the statement of facts, or?
Everybody needs to identify themselves.
yeah, who's here tonight representing the respondent?
Mr. Chairman, members of the board and council, my name is Samuel J. Brown, B-R-O-W-N. I'm here representing the applicant, the licensees, along with
Sarah E. Brown, B-R-O-W-N.
Thank you, Council. Chief Inspector Harris, you could proceed with the reading, please.
Thank you. Inspector Wayne Harris, Anne Arundel County Liquor Board. On August 9th, 2020, at about 5:45 p.m., this inspector arrived at the Anchored Inn located of address. I went to that establishment due to several complaints concerning the COVID-19 violations. The Anne Arundel County Health Department asked that we check the establishment, and also due to complaints that were arriving from citizens concerning large crowds not wearing masks and people just standing around. Upon my arrival, I went directly to the bar area and sat at a small table where I could observe most of the area between the hotel, the swimming pool, and the parking lot, including the boat bar. I observed several violations which caused concern immediately. A tent was set up on the parking lot, which I observed a female employee acting as a bartender selling drinks, which included mixed drinks there in a tent. And this is a violation of the health department rules and regulations, and therefore a violation of the liquor board. I observed several patrons also standing around talking to people, some of them with drinks in their possession at that time, and these individuals were violating the no standing regulation from the governor's proclamation. I also observed 2 tables which had 8 people seated at each of the tables. No more than 6 people is the maximum under the governor's proclamation. I also observed patrons standing at the bar talking to other patrons without mask on, and they were violating the safe distancing. They were walking up between seated customers, causing all to be in close proximity. The establishment was not overcrowded, but yet I observed too many violations in a short period of time. I looked around for a manager. And I observed a gentleman wearing a staff t-shirt and asked him if he could get the manager on duty, at which time he identified himself as the manager, and that person was later identified as Mr. Stephen Cooper. I explained all the various violations, walked him around, pointed out and showed him each of the violations that were still going on, and expressed my concern and asked him to rectify the situation as soon as possible. He introduced me to Ashley Hanglater, who was on the property. Ms. Hangglider is the licensee for the property. I then pointed out those violations to her. I also have photos that I presented as part of my case folder, which you should have as well. These photos will show all of the violations that I talked about, and there may have been more that I did not photograph. I did not have a violation book with me at that time, so I did explain to her that I was Ms. Hangglider, that is, and Mr. Cooper. Explained to them that I would return. I did return and issued citations for the violations. It should be noted that Mr. Stephen Cooper and Ms. Hangglider were very cooperative. And when I returned 2 days later and gave them the necessary paperwork, they had made quite a few corrections, which would help rectify some of the problems that I observed on the first visit. They did move some stools around, bolting them to the floor actually, so they couldn't be moved any closer than they were. They also had put some spacing, additional spacing in between the tables that they had there. They looked like they moved some of the tables off the floor around the deck bar. And also told me they were familiar with the violations and that they were making sure that they didn't seat more than 6 people to a table and so forth.
Thank you, Chief Inspector Harris. That concludes your testimony. Then, Mr. Brown, you may proceed either through proffer or through testimony or a combination of both. And please remember that you have half an hour to present your client's case.
Thank you. Can you hear me through this mask okay, or can I can take it off since I'm facing you all? You okay?
We can hear you.
All right, fine. Mr. Chairman, members of the board, a couple things, first of all. Number one, we requested this hearing tonight because we think it's important to have a hearing to look at what the rules and regulations are and to find out how we can correct if there's any problems in the future. First of all, though, looking at the violations, the first concern I have is that there's a violation listing that we're basically in public welfare, and that the second one is illegal conduct. But there are no citations from the health department showing that we're in violation of anything. While you all can say it's a health department violation, the health department has not determined that they are in violation of anything at all. I'm unaware of any hearings, any determinations, any findings by the health department. So as a result of that, I'd ask that anything regarding a health department violation be dismissed, because unless there's somebody here tonight as an expert to testify to the health department rules and regulations, it's very difficult to say that they are in violation. The second thing is that the allegation that they're not allowed to have more than 6 people at a table, that's not what the rule is. I'm looking at the July 7th, 2020 interim COVID report, which is an outdoor dining for page 8, which is the food study section. And it says restaurant and bars and social clubs that serve food and beverages to customers in indoor areas, in outdoor areas. Number 3, not allow groups larger than 6 persons to be seated together, except members of the same household. So the violation is not, you can have more than 6 people, but you have to prove that those people are not members of the same household. And that's part of the concern here. And the question is, how do you do that? What do you do when a couple has 5 children, a husband and wife, and their mom and dad live with them? Or when there's an apartment situation? And the problem here is that they're cited with a violation that isn't really a violation, because the violation isn't that you can't have 6 people. It's that you can only have 6 people unless they're in the same household. And as I said, I'm quoting directly from the facts on updated COVID-19 restrictions intended to address the increase in cases and help keep Anne Arundel County, put out by the county executive. And the main order that I have is dated July the 25th, 2020. And I'm really looking at page 8 from that order, which is referring to outdoor dining, which is titled at the top, interim COVID-19 food safety facts, FAQS is the way that word facts is spelled. So I look at that. I also look at the same rules and regulations, which said, and it asks the questions. Does the 50-person outdoor and 25-person indoor social gathering limit apply when serving general public customers at restaurants. Now, this is a response from the health department and from the county executive. No, as defined above, a social gathering does not include gatherings associated with patroning a business. So therefore, the issue, which was one of the things that called Mr. Harris here in the beginning, some complaint, the place was not overcrowded. It has not been overcrowded. And if you look at the pictures, the people that don't have the masks on are all seated and are being served alcohol and food on the thing. There are some other pictures in here as I look through, and you can see where the stools and the tables are separated apart, and the only people that are consuming alcoholic beverages are those who are seated. I looked through the pictures from Mr. Harris where he's showing the bar picture, and it's, how do I define this one? It's, at the top, it's shown as picture 175026 JPEG. There's no one there that is consuming any alcoholic beverage or food who is standing or walking. The other issue is that I'm not sure what you do, and we're learning an awful lot in this day and age. We're learning more every day about what you can and can't do with COVID. But these rules were just developing. For example, the health department came out and they told these people that, well, you're outside, so we don't see a need for masks on some of your people. That's what the policy was when they came out in July of 2020, when the health department talked to them. But we had the masks on everywhere, and all the employees are having masks. There are lines, and you're allowed to have lines as long as they're 6 feet apart and they're marked on the ground. That's part of the July 25th, 2020 directive from the county executive, and it's also from the governor. So there is a 6-foot situation, and they adhered to that on it. Now, nobody wants to be here, and nobody wants to be causing any COVID to anyone. We don't want to turn around and be responsible for someone getting sick. But we presented to you with pictures, which you have in front of you. I'm assuming you have all of our exhibit pictures and all that. And hopefully they're in the same order that we presented them, but we show the signs that are on the property. We show what's going on. We show that patrons must be seated, no standing. We have the governor's proclamation here, which is required to be posted, the third picture. Then you go to the pictures where you show, as Mr. Harris testified, we bolted down the tables so they can't be moved. For example, when there were one other person, when Mr. Harris was there, he noticed that somebody else was coming over the table. They pulled up a chair. We didn't have a chance to take care of that and get rid of that. I wish we could have, but we didn't. So now these are bolted down so they cannot be moved. And you'll see in all the pictures, there's signs on each one. You see the bar. These are not 6 feet apart. They are 9 feet apart. They've done everything, including the tables and other things, to be 9 feet apart. They've even showed how they've done at the bottom of the pictures, the exact screwing in. Now, I mean, the sign when you walk in, welcome with a picture of a mask. The next picture is restrooms. Now, they're required to have 2 restrooms on site. In order to make sure that there was no crowding and the people were separated, they now have 8 restrooms on site, portable restrooms that they brought out there so that nobody is bothering each other and their people are keeping their distances. And not only did they do this at the site, but they did it online too. They've canceled every event they had at the place, including their grand opening since March. We've given you one example of the event that was canceled, Wheels to Deals, which is a fundraiser situation that was canceled on it. We've given the others which they put online, as they tell you, what the signs are. We put 2 signs, one of what's in the store and one which they put online so that everybody knows exactly what's going on. They've told about the explanation of what you can do at the boathouse, and are happy to see you there. But you have to wear a mask, you have to find a seat, and you order drinks from the lines, okay? And these are rules that they are enforcing on a regular basis, on a daily basis. Mr. Cooper was the manager that night, and as he was talking to Mr. Harris, they saw something going on. He was talking to Mr. Harris, so he couldn't go over and he couldn't correct the situation right at that point. But as to the violations, as to the issue of the public health and the issue as to the illegal conduct, it's our position that, number one, that they have not violated the orders of the governor or the county executive. In fact, they followed them based on what I've just read. As to the public welfare, they haven't violated any health department issues because the health department has not cited them. The health department went out there, they came out a week or so later, and they advised them that they were there because the liquor board had complained. That's what they found out from the health department, and they came out to check it. And the health department came back and gave them a clean bill of health, but no violations, no fines, no nothing. Now, it's important to note that this place stays open late into the wintertime. It always has. They closed down last Thursday for good, for the winter. They're not going to be open because why? It's too many hassles, it's too many things, and there are too many rules. Even though this is an outdoor venue, it's not like the typical indoor venue where they have people walking around close to each other and there's no air. This is a complete outdoor venue. They try to follow every rule and regulation. And I have both the witnesses here tonight, Ms. Hangleiter, who is the licensee, and Mr. Cooper, who is the manager on site. Normally we'd have witnesses, as you know, because I like to call witnesses, who turn around and will come in and testify as to what they have done and how the place is in compliance. But because of the Zoom situation, we didn't want to expand too much. Plus, I know we have a limitation of amount of time that we can have based on the Zoom. And just so you also know, since this has happened, the general manager there has been replaced because they weren't happy when they looked at certain things. And they wanted to make sure that things were tightened up a little more. So the general manager is gone. They have hired a general manager with years and years and years of restaurant experience who is taking care of things down there right now. But for this COVID, that general manager would still probably be there. But they've done everything they can in order to protect and do what's right and follow the county rules and regulations. Now, I have proffered this on behalf of my clients. I'm happy to have my clients testify as to specific things. The health department, by the way, just so you know, came out there on August 17th, the second time. They were out there before and they cited no violations. August 17th, and they explained that the employees have to wear mask coverings on their faces, that you can't serve customers who are not seated, and the food service establishments ensure patrons are seated 6 feet away from each other. And that is all being taken care of. And if you look at all the pictures that Mr. Harris has taken, there's no pictures there of anyone being served who is not seated. And there's no pictures of anyone not seated who doesn't have a mask on, who's having alcohol, who's walking around. We can't stop everybody from doing everything, but we try to. And we're the first violation that I know of that's up here for the public health and welfare situation of legal conduct based on COVID. You've made others, and you may have had others. If you have, I haven't seen them and I apologize. But I'm prepared to allow either one of the witnesses to testify, to ask them any questions you may have about it, because we're here to comply. But technically, I'm not sure that there's a violation. And that's why on a technical basis, I make the objection as to the health department standard that there's no violation of the health department, because the health department controls their own things. And without a report from the health department, an expert saying you're in violation, I don't think we can go there. And secondly, as to the governor's, the conduct based on the governor and the county executive, I've just read the regulation based on the county executive, and I believe that we're in compliance on that too. So that would be my proffer. Did I miss anything on the proffer, Sarah? You all think I missed anything on the proffer? Well, they say I haven't, and I've talked long enough, but we will, I've opened this up to any questions you may have or any comments you may have. I could ask both of these people to swear to and affirm. In fact, I will. Have I made it, Ms. Hanleiter, have I made any misrepresentations to this board tonight? You've heard everything as I said it, and is it accurate and correct as to what's going on out there, what changes you've made, if anything, and what you believe were the situation on that evening?
Yes, sir.
Mr. Cooper, same questions to you. Is there any problems, anything I've missed?
No, sir.
Okay. Mr. Harris, I understand, was totally cooperative with you all too. He was very pleasant, no hassles, no problems, no scenes were made, and you all had a good rapport that night. Is that correct?
Yes.
Okay. And so is there anything else that you all, either one of you, need to add to what I've said?
I would just like to say we are doing our absolute best. When I met with Mr. Harris, I said he put citations, and I asked him, okay, what are the rules? And please just provide me with what the rules are. He provided me 4 different places. I went to print it out 280 pages of reading through every single thing that I could find and still couldn't quite determine the rules. And that's why I'm here today.
Mr. Cooper, anything else that you need to add, or is that fair? Go ahead.
All I can say is that we're so strict on the mask, the seating of 6 people and everything else. People come in and say, we're the only place in Anne Arundel County that enforces these rules. That's how strict we are doing this. Ever since this has happened. So we've tightened our belt and became, like I said, I've had people walk out because we enforce the mask so much.
People not only walked out, but as I told you, they closed the business early because of this. While this is a good place for an outdoor venue and the weather has still been good, they closed down to avoid any possible problems. So, Mr. Chairman and members of the board, basically our presentation. I don't know what questions you may have.
Brown, before you finish your proffer, did you, in the early part of your proffer, did you intend to proffer to the board that those tables where the inspector observed more than 6 people, the parties were related in fact?
Mr. Dales, I don't think that's our obligation. I think the issue is that you all have to prove that they're in violation of the code section. And the code section specifically said, not the code, but the COVID section specifically says that. So it's not our position, but you're here violating us. And the issue is, did we turn around? Did you have proof that those people were not? Is there any evidence that those people were not from the same household? And if we're allowed to have 6 people, and any more than 6 has to be from the same household. So that's my question. And so I'm not proffering anything about them because we didn't ask everybody for an ID, a passport, or their voter registration card to find out where they lived. We don't do that on the thing. They came in, and as the health department, one of the health department people told them, and we told them, somebody comes in and says, we're waiting for our group to get here. So somebody sits down and the others join them. Now it's impossible for people to pull up more chairs to these tables. We've made it impossible for all that. So even family groups of 8, unless there's something specifically where they come in now and they show and all that, and I don't even know if that's valid or not. So the issue is, am I proffering that to you? The answer is no. But I think that's an obligation before you can find them in violation of this this section, is that you all have to show that they are not within the code.
Thought that might be your view, but I was just asking for clarification on what you had proffered, and I think you answered my question. Thank you. All right. So if that concludes your case, Mr. Brown, I think I would ask, Mr. Chairman, do you have questions for the respondents?
Mr. Dales, do I need to move in these exhibits that we've had, or are they considered moved in already by the fact that we sent them to you?
Mr. Harris or Mr. Aronson, are those exhibits that Mr. Brown has referenced all in the record?
Yes, they were sent to everyone.
Thank you. Then I'd move them in if necessary. If not, we accept that.
Mr. Chairman, questions for the respondents?
Chairman John Maloney. It looks like you've made some great gains in trying to comply and doing some of the things that the governor wants and the county executive does. But we were asked basically to, as an arm, to go out and to, by the health department, to respond to complaints as well as to check on different licensees. And I think that's how Wayne Harris got involved with coming down to that particular location. And I think what he saw in a very, if you will, want to call it simple case, was people not wearing masks, people walking closely together, and he documented those things. And, that's in a very simplified way of putting it, what happened, as far as I can see. So I'm just going to make that statement and turn it over to any of the other commissioners.
Commissioners have questions? Commissioner Duffy, Commissioner Wilkins?
You're both muted.
You're mute.
You're muted, Mr. Bilkins. We can't hear you, Mr. Bilkins. There you go.
I know. I was squirming around to find the mouse here.
I missed what you say.
Yeah, that's the true quote of 2020 is you're muted.
I'm disturbed by the fact that you're making it appear, Mr. Brown, that there were no violations on your premises. You presented a very good case, but we saw it differently. And I don't want to belabor this thing at all, but the thing about the more than 6 people at a table, the responsibility falls on the licensee to see that occurs correctly. And yet it is also on our side to go and be sure that there is a violation. So we both need to work this problem to have it resolved. You can't just put it back on us. We didn't take names and prove familial relationships. That should have been done by the licensee if he's going to put more than 6 at a table. That's all I have to say.
You're muted. Otis?
Okay, this is Commissioner Duffy. Mr. Brown, did I understand you to say earlier in your proffer that the business was closed at this point in time because it was a seasonal business, an outdoors venue?
What I said is that they normally close in mid-December. They have now closed as of November 12, and they probably won't open up again until when it's safe to open up, whenever that is, and hopefully in the spring. But it's a seasonal venue, but they stay open until mid-December. Then they turn around and close down because it's an outdoor venue, as you know. They still have a license inside at the hotel area and things of that nature. But as to the outside service, they close it down. So they closed down early. It wasn't, with what's going on right now, there's just too many risks out there. And no matter what protections we take, we can't stop somebody from walking from one table to another and then stopping and saying hello to somebody along the way. We can't, as soon as we see somebody without a mask, we go up and we tell them, put on your mask. That's what's happening everywhere now. And that's what happened in the past, but there was some confusion. So we're all learning from this. And as Mr. Maloney said, we're learning from it. And as Mr. Copeland said, we're not trying to get out of this, but these are serious violations. We take them seriously, or I wouldn't be here with them tonight. And it's a serious violation. And therefore, sometimes we have to hold people to the letter of the law on it. And that's why when Mr. Gales asked me that one question, I came back and I said specifically, you have to prove the violation against us. And then Mr. Maloney said that the health department has asked you to do certain things. And I understand that the health department has asked certain things, but the health department hasn't violated them. And they haven't had a hearing at the health department to show anything and all. So the question is, where is that violation? And it's just like if we sell alcohol to a minor. You all come in and you prove that the minor is a minor. You prove that we sold the alcohol, and you have to do all that. You tell that the money was exchanged, and that is your responsibility to do that. And selling alcohol to a minor is a criminal offense, and you prove the criminal offense. The issue in this case is that nothing has been proven that way. So that's my comment, Mr. Duffy.
Okay, I appreciate your comment, and I appreciate you answering the question that it was seasonal or not.
Oh, I'm sorry. It's seasonal. I apologize. I thought I said that in the beginning. Is it seasonal? Yes. The season goes till December 15th and opens up again normally mid-March.
I got you. I understand the question and the answer. Thank you very much. I have no other questions, Mr. Chairman.
Interesting. I'm going to ask Mr. Harris to just jump back in here, and he's been involved in a lot of inspections. He's been involved not only in the Anchored Inn, but certainly throughout the county and working with our inspectors throughout. So if he would just make some comments, would appreciate that, Wayne.
Yes, sir. Wayne Harris, Chief Inspector of Anne Arundel County Liquor Board. A couple comments. We do have a health department representative in the audience. If anybody feels the need to bring Mr. Ford forward, he's available to answer any questions about whether those were health department violations or not. We also have 416 illegal conduct. This is in reference to the governor's proclamation. And when we were sent out initially as a reporting agency and then asked to participate as an enforcement agency. And 416 illegal conduct deals with the committing or allowing the commission on the premises of any act that is contrary to any federal, state, or local statute, law, rule, or regulation, or ordinance in accordance with the public peace, safety, health, welfare, quiet, and morals. To wit, the charge of 416. The observations I made in the photographs, contrary to what Mr. Brown said, I think if you need me to, I'd be more than happy to show you photo by photo where there are violations that are shown in the photo. I can point them out if you wish me to. If not, all I can ask you to do is look at the photos carefully and scrutinize them, and I think you'll see where the violations originated.
Okay. I quite frankly don't think that's necessary at this point, unless the commissioners think that. Hearing.
Mr. Chairman, from council and Mr. Blumenthal, if you're participating here, if you're able to communicate, I'd appreciate your responses here. But my view as co-counsel is that from the legal issues raised by Mr. Brown is not council's advice that you would need to dismiss either of the charges for lack of health department violations found by the health department itself. And with regard to the burden of showing that parties of greater than 6 were not families, I don't believe that the intent of the governor's regulation is that that the enforcement agencies would have to go and determine for every table with more than 6 people. Those were unrelated. Mr. Blumenthal, I appreciate your input on that because I don't recall hearing anything in the testimony from the inspector that there was any evidence that the people at the tables were related. And so if the order is, the executive order states that there may not be tables more than 6 unless they are from the same household. I don't believe that would require Mr. Harris to have determined that all these parties were unrelated. I don't think that duty is placed on Chief Inspector by the executive order. But Mr. Blumenthal, your thoughts on that issue?
All right, can everyone hear me?
Yes.
All right, I'm trying to get unmuted here. I concur with what the commissioners have said and what Mr. Dales have said, that there's strict liability here. And on Mr. Harris's training, education, and experience, which includes looking at reports from various regulatory agencies, such as the county health department, that he went out and not based upon that recommendation, that was just the motivators for him going out, and he independently confirmed violations to which he testified. Mr. Brown contests whether or not they were violations, which is his right to do so, and properly points out to the best of his ability that they may not be violations in the first place, and if they are not violations, I agree that they could be violations, and therefore I think the burden of proof switches to the applicants who have not demonstrated that there was no violation. What I've heard is, and it's an odd thing, the comments by Mr. Brown are heartening, quite frankly, and represent a concern and an effort to make sure that there will be compliance in the future. And we're all struggling with the meaning and interpretation and efficacy of the various executive orders that come out, but the board is charged with enforcing the law in Anne Arundel County and the law of the state of Maryland, and any violation of the law in the state of Maryland and the county of Anne Arundel, which the board takes as inclusive of executive orders, is a violation of the alcoholic beverage orders is by virtue of the code. So I believe the commissioners could find that there's been a violation, but in Mr. Brown's proffer is a uh, expansive uh, indication of how that problem will not again arise, which is under the theory of no good deed goes unpunished, and that offering to make sure it doesn't rise uh, means it could have arisen, not necessarily so though. So what I've heard is mainly that if the commissioners want, they can find there was no violation, or they can find there was a violation, and this is a violation because of the extreme measures taken by the licensee that could be used as mitigation of punishment should a violation be found. And that's my addition to the hearing. And the board will accept everything that Mr. Brown said as the actual testimony of the witnesses.
Mr. Chairman, I'd like to add to council's advice with regard to one of the charges listed in the case. There's the evidence from Mr. Harris that there were parties at the bar speaking to each other without masks on, and I think that what the board needs to determine is whether that evidence with regard to that charge shows a violation of parties of more than 6. So if you had people who were at parties of less than 6 at the bar, seated, speaking to each other, as the board presented evidence of violation there in light of Mr. Brown's proper testimony. And I think that's worth considering as the board decides how it wishes to enforce and administer the executive order here.
Mr. Dales, could I respond to that for a second?
Mr. Brown, go ahead.
Thank you. If you look at the bar pictures, the people that are seated at the bar are talking to each other are the ones that are drinking. And if somebody's drinking or has a meal, there's no obligation for a mask to be on. That's the rule throughout the whole state. If you're eating or drinking and these people sitting in a bar, there's no obligation for a mask. The people standing up are the ones that have to have a mask on if they have a mask and if they need a mask. So that's the only thing I'd look at there. The second thing I look at is the groups of 6. If you look at the photo 175113, it looks like there are 5 people sitting at a table in that one, and there's 2 people standing. I don't know if they were sitting at the seats. There's only 1 extra seat that I see there, which is 6. It looks like the other person came over and said hello to the woman sitting at the left-hand side. I don't know. And then when I look at the picture in the bar, a picture 174947, it looks like there are 6 people sitting at the table in that area there and 1 person sitting at the bar area. So that's the only distinction I would draw for you. But if somebody's eating or drinking, they have no obligation to wear a mask. So even if they're seated at the bar and they're eating or drinking, there's no mask obligation.
Thank you, Mr. Brown. I'm going to point out that we're at the 30-minute time limit now. And regarding Mr. Brown's final proffers, I think we should remember there is also the charge of serving customers who are not seated, which is required. And with that, I think we'll close the evidentiary portion of here.
Thank you.
I guess it's back to me.
Yeah.
Anything from any of the commissioners at this point?
Commissioner Pilkins, I would like very much to let you know that most of the experience I have in working for the Board of License Commissioners has been the breaking of laws. And there was no immediate damage other than the breaking of the law. The problem we have with the COVID situation is what we're doing is stopping people from getting sick. Yes, the law has been broken. But it's harder to forgive this because the only reason the law was written was to stop people from doing an activity that could infect other people. So let's keep that in mind as we get to the phase here of trying to find fault. It's quite different than what we've been doing for years, where there's a a law that simply someone skipped over and they violated, okay, be happy, just don't do it again. The problem, we only get one chance at this. If we infect people at that bar with those 3 people standing there and 2 of them get sick, that's the fault that we should have seen coming, and we shouldn't have let it happen in the first place. Now, I do agree that the licensee has learned by this and has complied wonderfully. And it's a well-run organization. We're all dealing with a lot of problems here, but I don't want us to lose sight of the fact this isn't a simple breaking of the law or the edict. Thank you.
Okay.
Commissioners, when a motion is brought, I would advise that you want to be very clear about your findings of fact and the facts on which you make a legal decision for a finding of violation or not. Otherwise, I think you could deliberate and discuss the evidence that you could presented, and then a motion would be in order.
Okay. So, there's some background music out there, discussion that's just getting feedback. If that could be taken care of.
Mr. Blumenthal, that might be your phone from our other conversation. You can mute it.
But anyway, just distracting. I guess what we're looking to do right now is to determine
Make a motion.
where the overall issue as far as the not compliance, etc. So we've got really an inspector going out there, making some determinations, and obviously there's a lot of work that's been done by the bar itself and making sure that there are no issues with regard to compliance. So I'm at a quandary here as far as, quite frankly, as to where we want to move forward. And I'm going to...
Mr. Chairman, I think with regard to the primary charge of there being more than 6 people at the tables, there's been a legal question raised by the respondent, and if you were to decide that you wanted to fine for a violation, that issue, that legal question could be raised in a petition for judicial review and determine there. If you wanted to decide not to find a violation there, then we will not have need to address that legal question that's been raised and find an answer yet. On the other violations, I don't think the same types of legal questions have been raised, and so you may choose to take the 2 separate charges independently and make motions in that manner.
So you're looking at...
Said differently, you could take the evidence presented for as the basis for violation of 3.09 and 4.16, 3.09 being the public welfare and 4.16 being illegal conduct, and make determinations regarding some of the evidence that has been presented by Inspector Harris, and make clear which pieces of evidence you're basing your motions on as to both rules. You could consider, for example, the violation of the party table sizes separately from the evidence presented about the failure to wear masks or to serve seated patrons.
Well, okay, let's since there's no further discussion, let's just take the public welfare 3.09 with regard to masks and...
Mr. Chairman, can we just merge those 2 together?
Yeah, we could. I think
Why don't we just merge the 2 together and let's vote on the thing and get over with this?
Okay, I'll entertain a motion then.
I move that we find the defendant guilty. We merge the 2 counts, find them guilty, and a fine of $500.
We have a second there. For discussion, I'll second it.
Second.
It's been second. Okay, any further discussion? Those in favor of the motion?
Aye.
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 The motion is carried. Thank you.
Thank you.
Nice job, Sam. Sorry.
That does include costs, is it? Well, is that correct?
It does include, no, it does not include cost.
Okay.
So the motion would be to include court costs.
Yeah.
So is there a new motion being made here, Commissioner Duffy, to include?
I think it was clarification.
Yes, I make a motion to amend the violation to include that of court calls plus the $500 fine for the violation of combining the two violations.
I was saying the same thing, it just sounds different.
Okay.
Yes, I'm saying the same thing, but yes, I made an amendment to the motion.
Okay, is there a second to that amendment?
Second.
Okay, those in favor?
Aye.
Aye. It's carried. Thank you again.
Okay. Thank you, everybody. Next case, we're going to call Champs. Mr. Aronson, if you want to invite our guest. Next case is Champs Pizza and Subs, known as Raoul Pizza Incorporated. Ashley Raoul, president. Sonny Raoul, manager. Inspector Roland Marshall, and Chief Inspector Wayne Harris. Ian Jeffers, a compliance officer with the Anne Arundel County Health Department. Inspector Jim Ford, a compliance officer with the Anne Arundel County Health Department. And Jennifer Kenny, a compliance officer, excuse me, with the Anne Arundel County Health Department. This is a Class H beer, wine, and liquor license with entertainment, late hours and Sunday license, 604 Crane Highway North, Glen Burnie, Maryland, 21061, no restrictions. Violations are as follows. Violations of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.09, Public Welfare. Reference Board of License Commissioners for Anne Arundel County, violation notice number 2265. Supplement report dated September 11th, 2020. Next one is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct. Reference Board of License Commissioners for Anne Arundel County, violation notice number 2265. Supplement report dated September 11th, 2020. The third one is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.05, sanitation and safety. Reference the Board of License Commissioners for the Anne Arundel County, violation notice number 2265, supplement report dated September 11th, 2020. That is the second violation, or the first of these two violations. There's another one. Do you want to hear both of them read out now, Mr. Blumenthal?
Yes. For efficiency and judicial economy, let's try them together unless there's an objection.
Will do.
Is there any objection, Mr. Brown?
Okay. All right. Item 4, violations of rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.02, cooperation. Reference Board of License Commissioners for Anne Arundel County, violation notice 2267. Supplement report dated October 30th, 2020. Violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.09, Public Welfare, Board of License Commissioners for Anne Arundel County. Violation notice 2267, supplement reported dated October 30th, 2020. Item 6 is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct.
Figured it out.
We're good? Okay.
Reference the Board of License Commissioners for Anne Arundel County, notice 2267, supplement report dated October 30th, 2020. And the last one is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 309, sanitation and safety. Board of License Commissioners for Anne Arundel County, notice 2267, supplement report dated October 30th, 2020. And anyone wishing to testify for or against in this case, please come forward. Raise your right hands. Mr. Aronson, I'm going to be testifying, so I will as well.
You solemnly declare and affirm on the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
I do.
I do.
I do.
If I could just add, I did receive an email from Mr. Bittner at 6:07 with 3 exhibits for tonight's hearing, but since they were sent after the hearing was started, I have not been able to forward to the board. Just so you're aware.
Well, I think it's appropriate for the applicant to have the ability to put in exhibits as part of his case in chief. And the applicant's not held to the 5-day rule prior to the hearing itself, because the applicant has the right to respond to matters given to the applicant within that 5-day right. So the board will accept those as exhibits, subject to any cross-examination or inquiry by the commissioners. Mr. Chairman.
Yourselves and state your name and address for the record, please.
Okay.
Mr. Chairman, members of the board, good evening. This is Richard Bittner on behalf of the licensees. I hope everyone can hear and see me. Happy to see Ms. Hagner back with us, though I see she just left. My clients are here, Sonny and Ashley Lewal. They have been sworn. The board should have received our admission of these violations. We notified the board on Friday, November the 13th, that we were not going to contest these violations. In fact, I suggested if the board was so inclined, they didn't need to have their witnesses here present, but we are not contesting these violations. We simply want to be heard in mitigation, make the appropriate motion that the violations merge for disposition purposes. So we are not contesting violations on September the 11th or October the 30th.
All right, can the board hear me? This is Harry Blumenthal.
Yes.
All right, predicated upon the representation of Mr. Bittner in behalf of his clientele, the board accepts the admission of guilt with regard to all violations, but obviously will afford to Mr. Bittner the opportunity and right to either proffer by testimony or have actual testimony as to why it's appropriate to have mitigation in the sentencing. Ms. Dales, it's all yours.
Mr. Bittner stated that the witnesses had been sworn. Were the witnesses in fact sworn? All that you're going to have provide testimony, Mr. Bittner?
If the board allows, I would like to make a proffer at this time.
Go ahead.
Initially, I want to move in our exhibits that we filed, exhibits 1, 2, and 3. I want to confirm that the board received our filing of earlier today containing 2 of those exhibits and our memorandum for why a modest fine should be imposed in this case. Gentlemen, did you receive that?
Yes, I did receive it.
Thank you. As indicated in our memorandum, my clients come before you today. Really, there's no other way to describe it except beaten down. As you well know, this is a small family run operation, a husband and wife. They employ a lot of friends, a lot of family in the business. They have struggled throughout the COVID-19 to remain in business, to remain profitable, and most importantly, to remain compliant with all applicable rules and regulations. As the board well knows, as a result of complaints, the health department, appropriately so, investigated the establishment. The liquor board followed up on that, found violations. Masks, unfortunately, were not worn by staff in the heat of the kitchen. There were occasions, in spite of their best efforts, when patrons removed masks, got too close together. We concur in Commissioner Pilkins' comments that, this is different. This is different than a normal violation because it has potentially long-reaching consequences. And the Rawal family understands that. They understand it quite clearly because they were shut down for close to 3 days. As outlined, during that 3-day closure, they counseled with me, they counseled with themselves, they looked inward, and what they did as a response to that was extremely proactive. They went in, they took a look at their operations, and what they did, gentlemen, was that they had a meeting with all staff. All staff had to execute a new written policy. You have a copy of that. That is a no tolerance policy. If masks aren't worn, if all rules and regulations aren't fired, then they're terminated. No ifs, ands, or buts. It doesn't matter if you're a cousin, a high school friend, you're gone. And I think they've made that quite clear to all staff. They made it quite clear. And I think the staff gets it after they were out of work for 3 days. When the restaurant was closed down, the Rawal family did not pay their staff. Their staff suffered a pecuniary loss by being unemployed for those 3 days. They know that if they violate, they're unemployed permanently. And I've advised them that they wouldn't, if they're terminated, they would not be eligible for unemployment benefits because they were terminated by cause. So I think the staff understands it. Certainly my clients understand it. Additionally, besides having the meeting and the retraining and providing copies of the governor's orders and the applicable rules to each staff member, the Rawals have purchased uniform mask coverings that all employees use. They've posted additional signage, and that was the late filing that I submitted to you just a little after 6. That's Exhibit 3. That's photographs of the additional signage that they've placed in the establishment. So what we have here, Mr. Chairman, members of the board, number one is we have no violations of the alcoholic beverage rules and regulations. There's no sales to minors, there's no late hours, there's no over service. We have, some might call technical violations. We don't choose to assess them as that. These are serious violations, they take it seriously. They were closed for 3 days. We estimate they lost $15,000 in gross revenues during that closure. But most respectfully, Mr. Chairman, members of the board, the penalty that has been imposed on this family and on this restaurant goes far beyond any monetary or economic loss that they've sustained. You may recall that when we came in for the new license, this had been an establishment that had been operating as a pizzeria restaurant for quite some time, and they had received a great deal of popular notoriety with their food. They have the largest pizza on the East Coast, size pizza. They were featured in diners, drives, and dive-ins, a number of cable TV shows. They received glowing reviews in local press. They were followed quite extensively. They had a growing clientele that was swelling every day. That's all gone. The internet, when they were shut down by the health department, and of course that was put on the public website of the health department, the things that were said by the community about this restaurant and about the Rawal family, I'm not even going to bother to repeat here because they go beyond the pale. This is an outstanding restaurant with outstanding food that hopefully is going to be able to recover from this closure and the just exceedingly poor press that they have received, and justifiably so. The community has a right to know who's in compliance, who's not in compliance. Now, in that note, fortunately, to echo Commissioner Pilkins' comments, fortunately, no one got sick. Thank God. I can only imagine. I know how Ms. Rawal has been just beside herself with this, the closure, the face of a loss of a business. This is how this family supports their family. So they get it. They get it. And they get it, because of the strong remedial actions that the health department has approved. And the representative of the health department can speak to that if you feel it's appropriate, in having uniform masks, in having a written policy, in having a reevaluation of how they conduct their staffing and admission into the establishment of patrons. Most respectfully, we ask the board to merge these violations into one for each offense and impose a modest fine in this case. My clients are happy to answer any questions that the board may have. And I'll conclude, because I'm not sure that Ms. Hagner heard me, but it's good to see you on the screen. Hope you're feeling better. Thank you.
Chairman, any questions?
Yeah, this is the chairman, John Maloney. Yeah, thank you very much, Mr. Bittner, for detailing what the Champs has done as far as moving forward and taking care of many of the concerns of the county executive and the governor on the COVID. But I'm sorry they're beaten down, but they virtually had everything within their control to basically move forward. We had 3 inspections, and they were in violation of those 3 just from the alcohol beverage group. And I believe the health department was in there at least twice, pleading with you to more or less follow the guidelines of the county executive. So again, I'm sorry that had happened. I guess my question would be, what took you so long?
Well, I would just like to say that we have been trying extremely hard. We take it very seriously, not only
I think
for
the respondent should first state your name.
I'm sorry. My name is Ashley Rawal. My personal address is 8158 Meadowgate Circle, Glen Burnie, Maryland. Yeah, so we have really been doing our best. The whole pandemic has been nothing short of a test of will to succeed for us, and we are trying not only an issue of public safety, but we have small children at home. We don't want to get sick. So it's a matter of we are doing our best to control the public. And literally, if we're not there, we're watching the cameras from our phone. We're calling our managers saying, hey, someone just got up and went to the bathroom without a mask. Meet them at the bathroom with a mask so that they can walk back to their seat wearing a mask. Like, we are trying, like I said, we were not contesting anything. Unfortunately, it's extremely hot in our kitchen, and I'm not making an excuse, but more so offering an explanation as to why it could happen. But unfortunately, some of our employees were letting their mask fall below their noses. Just like with any company in a work handbook, you set in rules, unfortunately, employees break them. But we did take it very seriously. Like I said, like Mr. Bittner mentioned, we didn't pay anyone over the time that we were closed, and we told them, unfortunately, we're now experiencing loss, and it's at the hand of a lot of you. So when it comes to our employees, we put in a whole new, we put in a action plan so that it doesn't happen again, a no tolerance policy. We let them know that, termination is going to happen if they don't comply with the rules set in place, because we as a business owners, but even as parents, cannot afford to have the improper use of face masks continue or to happen again. So it's not, it's just unfortunate that it's like every time we turn our backs or we're not doing something, we literally have to be there all the time or on the phone watching the camera to make sure that one person doesn't get up and walk to the bathroom, or two guys coming together, they don't pull their stools close together at a bar, So we are trying, we have been trying. With the close down and the violations, I think the 3 days, it brought into reality that, we're trying very, very hard, but now there's no excuse, try harder, we gotta do better. So now it's one of us are always there. We hired someone who can be there like a security guard at a nightclub, just to enforce face masks, just to make sure that no one is improperly wearing their face mask, to everyone's social distancing. We had an issue with one of our employees that complained that his face mask fell down because it was too big. Okay, so now we are supplying our employees with uniform face masks that there is no excuse because they adjust behind the ears. So we are taking every step possible to make sure that from this point forward, these unfortunate things do not happen again. And we take full responsibility for that. But I can assure you, we are trying and we do take it seriously. We don't want to get anyone sick. We don't want anyone getting sick because of us. We don't want our own children getting sick. Or I have a mother with cancer and she is of the lungs. I don't need her getting sick. So COVID is something we take seriously. We're doing our best, but we're just going to try to do better from this point forward.
Thank you. I have no more questions. Any of the commissioners, questions?
I don't have any questions, Commissioner Pilkins.
This is Commissioner Duffy. I don't have any questions.
Okay. Phil has just stepped out for a moment. Is Harry there? We just move forward?
I'm asking Harry to unmute.
Yeah, okay.
Mr. Chairman, could we get one of the health inspectors to comment on what they found and as well as their thoughts?
We could do that, I think.
A good point, Otis, thanks.
Yeah, good point. Wayne, do you want to, Mr. Harris, you want to?
Yes. If I may, Inspector Ian Jeffers, who was here, was on the second offense or the first one tonight. And Mr. Jim Ford, who was also here, along with Inspector Jennifer Kenny, were on the second or the last of the three. So if you want to hear about any of the particular ones, they can do it, or they can both mention what they found in general. It was Mr. Ford and Ms. Kenny who were involved in the closure on the last offense. So I'll leave it up to you who you wish to question, but they're all here.
I would like to hear the reason and significance for why they closed the establishment. That was the reason.
Mr. Ford, identify yourself, please.
Jim Ford, Compliance Inspector, Anne Arundel County Department of Health, 3 Harry Truman Parkway in Annapolis. It was actually me on both inspections. The initial inspection was on October 30th, which was with Chief Harris. And I observed 4 employees, including the general manager owner, improperly wearing masks. They were well beneath the nose. And 1 employee was wearing a mask beneath the chin. So we did issue the OIC and let them know that we'd be returning for reinspection, which occurred on November 2nd at approximately 7:30 p.m. And I witnessed 2 employees clearly not wearing masks, wearing the masks beneath their nose, and 1 employee not wearing any mask at all. And that's when we issued the second order for immediate compliance for the mask violation. And then I joined Jennifer Kenny the next day to shut down the facility.
Jennifer Kenny, Environmental Health Specialist, Anne Arundel County Health Department, 3 Harry Truman Parkway, Annapolis, Maryland. So based on Mr. Ford's inspections from October 30th and November 2nd, where 2 orders for immediate compliance were issued. The facility was closed at approximately 12:45 on the 2nd, with instructions for reopening, which would have been included a hand-delivered letter and a letter sent via a return receipt, basically going over all the requirements for reopening. And we did receive the letter, and then Mr. Jeffers opened the facility on the 6th.
If I may, I'd like to invite Inspector Ian Jeffers to maybe give us a quick summary of our event, which was the second visit. Inspector Jeffers?
Yes, Ian Jeffers from the Anne Arundel County Health Department, 300 Hammonds Lane, Brooklyn Park. We did an inspection on the 11th. The findings and the actual complaint inspection was just that upon visiting the facility, the patron was actually there and witnessed a couple employees not properly wearing their face mask. And not only that, on the internet, they viewed social media. They viewed the facility employees not wearing a mask. So again, I did a joint inspection with Mr. Wayne Harris, where we then went to the facility and we did have a few employees not properly wearing their face mask. Not only that, on the cook line, there was an abundance of employees all on top of each other. I have here in my notes that it was 8 employees on the cook line, not properly social distancing, so that is a violation. And also with the face mask and a few patron violations as well, with not properly wearing face masks while in the facility. I've been over again with the incident that happened for the most recent closure, that I did actually speak with Sunny about the situation and actually delivered the notice of suspension, where, just like they stated, was the fact that they did have a comprehensive strategy plan in order to correct most of the violations, actually all the violations, to which then was approved by our department so they could reopen as well. But that would cover our side.
Thank you. Mr. Chairman, is that the limit of their testimony?
I have a question, Chief. You said the 11th, Mr. Jeffers. When did you visit? What date?
So that was on September 11th at 7 p.m. That was the joint inspection with Mr. Wayne Harris.
Well, Mr. Ford went in, what month was Mr. Ford's visits?
October 30th and then November 2nd.
This is the second and third offense, Commissioner Pilkins.
Yes, that's what I'm trying to get to here.
My apologies.
Yeah, I got kind of confused. All right. So you went, but you were introduced by saying you said you went back in to open the restaurant in your, maybe.
Yes.
Mr. Ford.
So September 11th was the first offense. My apologies. September 11th was the first offense where I actually did the initial inspection and then a re-inspection where they then came in compliance. The next inspection would have been Jim Ford's original complaint and inspection, where they actually closed the facility down. Once the facility was closed down, the notice of suspension, I was the one that actually delivered, where then the facility was giving me the plans for reopening the facility and remediation of those violations.
All right, let me verify. September 11th initial. The next one was October the 30th. And when did you close the restaurant?
November 2nd.
November the 2nd.
No, the facility was closed on November 3rd.
November the 3rd.
So Commissioner Pilkins, I might be able to clarify even further. So there were 2 separate complaints. Ian addressed one complaint which required 2 visits, an initial visit and then a second visit in which he found them in compliance. I went out later at the later date to inspect to follow up on a second complaint, a wholly new complaint. And so my initial visit in connection with that complaint was on October 30th. I found violations with Chief Harris, and my re-inspection after I issued the order for immediate compliance in connection with those violations was performed on November 2nd, at which time we decided that the facility needed to be shut down. So I returned the following day with Jennifer Kenny to shut it down.
Okay, that fixes it. All right.
So the violation actually occurred, Mr. Ford, on November the 2nd, and it was closed down on November the 3rd.
Yes.
Correct.
Okay. Now I have a chronological idea as to what the events.
Okay, Mr. Jeffers, what was the second date? You had September 11th, And what was the next date you went back to re-inspect?
So my initial inspection is, like you said, 9/11. I came out 5 days later to talk to Sunny, which would have been 9/16. We had discussion about the violations and also the fact that I looked over the facility and there were no violations.
So they fixed it?
Yes. Upon the
On the
inspection, so that would have
16th,
been.
you were there? Okay.
Yes, I did not have any violations for that day, so then the complaint was able to be closed out.
Okay, thanks. I'll sit and listen for a while now.
Mr. Harris, how was their overall cooperation?
They did everything we asked them to do, but I think the inspectors would agree with me when I say that they were a little disgruntled and upset about it. They seemed to, Sonny particularly seemed to have what he felt were excuses, and we explained to him that, you know, a mask that moves around on his face and doesn't fit properly, and you know, was not a reason not to change mask or have a reason. But as far as doing everything we asked at that time, they did.
Okay.
We're still getting. Well, that's okay. I won't go into that. As far as the cooperation, like I say, they did what they were asked, but they were very disgruntled and not happy about it, but at the same time, respectful.
Are there any other questions?
Commissioners have no other questions, and I think the chairman should close the evidentiary testimonial portion of the hearing.
I didn't get that.
If there are no more questions from the chair or the other commissioners, then we should close the evidentiary and testimonial portion of the hearing.
Okay. All right, I'm going to make a motion that we accept their guilty plea and that we fine them $1,200. Is there a second?
I second it.
Any discussion? Those in favor?
Aye.
Aye.
Aye. The motion is carried.
Mr. Chairman, this is Harry Blumenthal. Before you close the hearing, are there any more cases?
There's one more.
Okay, I'll wait till then.
Okay. That motion
Mr. Chair, does that cover cost?
And cost. That covers cost.
Okay, thank you.
Okay, thank you, everyone.
Thank you.
Mr. Chairman, members
I'm going to call the third case, which is Lakeshore Tavern. We're going to have two witnesses, I believe. Three counting myself, Inspector Frank Faulkner and Sherry Hudson, who is an owner, John G. Hudson, who is an owner, Rachel Miller, who is a bartender, and Inspector Faulkner. This is a Class D licensed beer, wine, and liquor with music and Sunday special licenses. Address of 1342 Lake Avenue, Pasadena, Maryland. No restrictions. We have the following violations. The first one being a violation of the rules and regulations of the Board of Licensed Commissioners for Anne Arundel County. Chapter 3, Section 309, Public Welfare, reference the Board of Licensed Commissioners for Anne Arundel County, violation notice number 1540, supplementary report dated August 10th, 2020. Violation of the rules and regulations of the Board of Licensed Commissioners for Anne Arundel County, Chapter 4, Section 416, illegal conduct, reference the the Board of Licensed Commissioners for Anne Arundel County, violation notice 1540. Supplement report dated August 10th as well. Violation notice for the rules and regulations of the licensed commissioners for Anne Arundel County.
I should have did my hair.
Licensees, please.
I'm sorry.
Mute your microphones, please.
Thank you.
Aye.
Okay. Violation of the rules and regulations, Board of Licensed Commissioners for Anne Arundel County, Chapter 4, Section 416, illegal conduct. Reference the Board of Licensed Commissioners for Anne Arundel County, violation 1540, supplement reported dated August 10th, 2020. Number 3 is a violation of the rules and regulations of license commissioners for Anne Arundel County, chapter or section 3.02, cooperation reference. The Board of License Commissioners for Anne Arundel County violation notice 1540, supplement reported dated August 10th, 2020. The 4th is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, chapter 3, section 3.02, cooperation, referencing the Board of License Commissioners for Anne Arundel County violation notice number 1529. That was dated May 27th, 2020. Violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, chapter 3, section 311, sales and consumption adjacent to premises. The Board of License Commissioners for Anne Arundel County violation notice 1529. Supplement report dated May 27th, 2020. The last is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, section 3, section 4.16, illegal conduct, reference the Board of License Commissioners for Anne Arundel County violation notice 1529. Supplement reported dated May 27th, 2020. Okay, anyone wishing to testify, please raise your right hand. Mr. Aronson, the administrator, will swear us in. I will be testifying along with Inspector Faulkner. Oh, you're muted, Ed. You're on mute.
Thank you. Do you solemnly declare and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, would everyone please state your name and address? I'll start off. I'm Chief Inspector Wayne Harris with the Anne Arundel County Liquor Board, 2660 Riva Road, Annapolis, Maryland. Inspector Faulkner.
Inspector Faulkner, 2660 Riva Road, Annapolis, Maryland, 21401.
Okay. Mr. and Mrs. Hudson.
John G. Hudson, 1637 Concordia Drive, Pasadena, Maryland. And I'm joined by my sister, Sherry.
Sherry Hudson, 8458 Main Avenue, Pasadena.
Okay. Thank you.
1122.
Mr. Dales, did you want a statement? This is 2 separate incidences also on 2 separate dates, as you probably have noticed. There was one in early May and then one later on this year. Inspector Faulkner, Frank Faulkner, was the inspector in both cases. I was with him in one of the incidents. How would you like to proceed?
Is the board seeking to hear these violations together, or are we going to hear them separately? If we're going to hear them separately, I think that we can just ask the respondents to state their case, and I'll proceed with that. Mr. Chairman, how would you like to?
That's fine. Let's do it.
For the respondents, you have 30 minutes to present your case, and you can do that either by proffer or by presenting testimony for the commissioners to hear. And we'll let you know when your 30 minutes is up. How would you like to proceed?
Okay, and thank you, board, for hearing us this evening. I know it's been a long evening. It's my recollection that the first violation that happened in May was the violation of the carryout. It was something that we, as a very small family-owned operation, was experimenting with. We were performing this operation, this carryout, in compliance with what we interpreted the law to be at the time. At the time the inspector came, I think we had a couple people that were in the parking lot that had just received their carryout. And that was the premise of the violation. So we're not contesting the observations from the inspectors. This was just the case where we did our part we have a very big parking lot, and people were moving on about their business with their carryout. And that was pretty much the case of what we understand it to be. The second violation,
So pause there. Mr. Chairman, if that's the testimony from the respondents, I think I'll suggest that the chair first and then other commissioners ask any questions they have with regard to that incident.
Yeah, I have no questions at this point. We'll hear from the inspectors, right?
That's right.
Okay, I'm good.
second violation was.
No, hold on, let's just finish with this. And so for the first violation, Inspector Harris and Inspector Faulkner, and you respond to the testimony and present the case to the commissioner.
Okay, let me just start and I'll turn it over to Inspector Faulkner. This was a situation where we had a complaint. Inspector Faulkner has that particular area. I called him, asked him if he could go out there and check the complaint, make the observations. I did tell him that I was in the area, in the Pasadena area, if he needed me or had any questions or needed assistance. If you don't mind, I'll let Inspector Faulkner, who wrote the report, go ahead and read his report if that's what you want.
Mr. Faulkner.
Inspector Faulkner, on this date, requested by Chief Inspector Wayne Harris to check above establishment for drinking at establishment. Arrived across the street from the establishment at 5:35 p.m. and observed two people sitting at picnic tables with red umbrellas. Establishment had several new picnic tables. A couple of people from upstairs apartment walking around on parking lot, to and from cars. As of 6 p.m., no patrons came to pick up food. At 6:05, met with Chief Wayne Harris and proceeded to parking lot of Lakeshore Tavern. Two of the five people at the picnic table were drinking a beer and a second liquor in a glass. Sherry Hudson removed two empty beer bottles from the table. The three other patrons received 3 orange crushes in plastic cup with no straws and lids. They left the establishment with no food. Wayne Harris explained the violation to Ms. Hudson. A ticket was given. The bar door was locked and no patrons were inside. 1 beer bottle at front of the establishment by bench. Pictures were taken by Chief Inspector Wayne Harris. That concludes the report.
Thank you. Now, Mr. Chairman, if the commissioners have questions about this first violation, we could do that, take care of those now.
I mean, my question is the 5 people were guests drinking outside? Is that how I understand it?
If I may, no, I'm sorry, go ahead. I apologize.
If the question is directed to the respondents, their microphone is muted, so unmute them.
I'm sorry. Yes. Can you hear me now?
Yeah, I can hear you fine.
Okay. So it's my understanding that 3 of the patrons in the parking lot received carryout. My sister can attest that they received carryout with a lid. Where that lid went, I cannot tell you. We also have a rental property on premises, so there are other people that come and go from a residential perspective. The picnic tables were placed there because we were under the understanding that there would be outside venue coming shortly, and actually that very day. So they were placed there for anticipation of us opening up and actually trying to create some sort of business. This is a very small business in a community, so many eyes are interested in what happens here. We're respectful of that. We've lived within that environment for 75 years here. So there's a lot of people that had questions in this COVID times, and we walked very slowly back into business. And, this was just a very early indication of what we had to deal with. And I feel like we've done a good job since. We feel like, you know, we had all the tools in place based on the information that we were given, which was very dynamic, as we all know. And that's really it. We don't have a big staff here. We have just a couple of us that work here, and we just try to hang on. So we've implemented all the policies and procedures regarding masks and whatnot, and we've been very cautious since then.
Thank you. No other questions.
Are there questions from the other commissioners?
This is Commissioner Duffy. I have one question as to why was the bar door locked and there was no entrance into the bar, but yet you selling beer?
Well,
according to the statement, it stated that the bar door was locked and no patron was inside.
That's correct.
So that's an indication that we weren't comfortable opening under the conditions that were existing at that time.
And we did carry out anyway.
We were complying with our carry-out license and trying to maintain and open up a little bit of business under the carry-out venue that we have. And it was very limited, and it had very limited success as well.
Okay, thank you. Okay. I have no other questions, Chairman.
Okay.
Commissioner Pilkins has just a general question. You do understand that your license provides for you to have to sell food with any alcoholic beverage. So if a person finishes their food, finishes their drink that they bought, and you come back in for a second drink, can you serve them?
Can we serve them? I don't think I understand the question.
It's sort of a trick question, and I only wanted to generate some conversation for you since you're new in the business. And the answer to my question is it depends. If they finish their food, finish their first drink, and then come back in and say, I'm finished, and dump the trash in trash can, and then order an orange crush, can you serve them?
According to our license, I believe we can.
Okay. Technically, you can't. But as long as their food had handled, I don't think anyone would violate you for that. But it's one of those things that you have to deal with in this business to be able to control your alcohol. So someone comes in and gets a salad and then orders a succession of beers after, we can't do that. But if someone comes in and wants another orange crush and you just finished their meal, I don't see a problem with that. But I thought I wanted to have that little discussion with you about it.
If I may, just as a point of interest to the commissioners, one of the photos you have there show 4 gentlemen sitting at the picnic table. One of them has a glass drink in a glass bottle, not a bottle, but a glass. He was not one of those that was given an orange crush to go or anything like that. And that was one of the disturbing things, is that we had bottled beer out there open, and we had this gentleman drinking what appeared to be whiskey. I asked him if it was alcohol, and he acknowledged that. So that just kind of sealed the deal, as the fact that they were consuming on the premises. And at that particular time, that was against the COVID violation, COVID proclamation
Well, that was something I asked you about our tenants. We do have tenants here. We have two sets of tenants. And they thought that because they rent and they pay rent, they were wondering what the,
But what they had to adhere to.
right,
And
exactly.
we know that answer with respect to maintaining
Right.
the business. To be more specific, the two people that you had mentioned, one with a beer, the other, I believe, had a glass, but I don't think it was alcohol. I think they were served water. They were doing some work for us on the back of the property.
Okay, well, he answered that it was, because I was very specific.
Attest to that? Because I don't think we're open for that at all.
Okay, well.
I just.
If you look closely at the glass, it has a orange tinted liquid. You know, I did not taste it, of course, but because of that, I asked him, and he said yes. He says, but I'll finish it. I said, well, I don't want you to rush it, but you can't be drinking here. And as you know, even if he's a tenant upstairs, he cannot come downstairs and consume alcohol on your property with your license.
Right.
Yeah, we understand that.
All right, I apologize. I didn't mean to get off track.
Are there questions from the other commissioners?
This Commissioner Duffy, I have no other questions.
I think that a motion to either take an action with regard to the first violation or to postpone that action until after hearing the evidence on the second would be in order. So, Mr. Chairman, what's your pleasure on that?
Why don't we act on the first one? Is that what you would recommend?
Before you act, I'd just like to just to throw in the fact that we've been in business a long time. We've been here 75 years. The file down in Annapolis is probably 2 feet thick, and we haven't had any violations in the past. We truly try to uphold everything that's required of us to keep our liquor license intact, and we're respectful of the community and where we are, how we act, and I'd just like to throw that out there for consideration.
All right, thank you. I think we should have the record closed with regard to the testimony on the first violation, and a motion is in order with regard to your action on the first violation.
Ed, let me ask you a question, or Judy. The 2 violations out there, we've settled any of them in the past? Never mind. I'm okay with
I don't
that.
understand.
Yeah.
I'm not understanding your question.
They haven't paid anything, any fine?
No. They chose to come to the hearing to defend themselves.
Mr. Chairman, this is Commissioner Duffy. If I may interject, could we not just hear the second cases? The second case, since both violations was illegal conduct and failure to comply.
Mr. Chairman, I think you could do that. If that is but you could take a motion and see what the board commissioners would choose to do. My suggestion to hear them separately was for the purposes of evidence, to be clear about the evidence about the evidence being for each specific violation. But you could choose to do either thing, either to postpone your action now and then take action on both with 1 or 2 motions later, or you can take action on the first violation now and move on to hearing evidence on the second.
Let's move on and hear evidence on the second.
All right, I think we should hear from the applicants and respondents again, as we did with the first violation. So with regard to the second violation date, the respondents care to provide testimony or to make proffers as to guilt?
I think that we concede on the evidence that's been brought forth there. We've taken action to terminate that employee who was given proper instruction. She knew what to do and failed to do that. So she's no longer with us. We comply with the mask requirements now, and feel like we're doing a fairly good job at that. there's just times where you just can't control everything, and this is one of those times.
So with that proffer, I think we can move to questions from the chair and the other commissioners. Mr. Chairman, do you have questions?
I don't have any questions on this. No.
So the employee that was fired is perhaps Rachel Miller?
Yes, unfortunately, and she's been with us for about 6 years.
Yeah.
And it's just unfortunate. We're doing the best we can. We've implemented cameras and we're to beef up staff as much as we can. We have tattletales on each other to keep everybody mindful of keeping their masks and their social distancing. And we're just doing the best we can to keep our business alive and keep everybody safe.
I owned a restaurant for 10 years, so I know where you're coming from. So
This is not one we actually purchased, so.
Yes, this
kind of
is
thrown into
our
this.
grandparents' legacy. But yeah, we're more of a tavern than a restaurant. But although we've been beefing up on the food a little bit more, you should come check out our crab soup. Homemade.
Questions from any of the other commissioners?
I have none.
This is Commissioner Duffy. I have no further questions. And thank you, Counselor, for your comments in reference to combining both cases.
That's why I think we should close the record for testimony and evidence on the second violation and then entertain motions with regard to both violations and be specific as to your action on each separate violation.
Don't want a violation of any kind. No violation.
The respondents, that's a recommendation that the board make a motion to some effect. It does not indicate what they'll decide.
Exactly. Do we have anybody out there entertaining a motion?
Well, I will make a motion, Mr. Chair, in reference to the individuals being proactive on both cases and making the necessary correction in regards to everything based upon the epidemic that we're going through and crisis that we're going through at this point in present time. And their ability to terminate a 6-year employee as a result of these two cases. I make a recommendation and a motion that we fine them $250 per coach cost. That's my motion.
Okay, is there a second to that?
second,
Okay, any discussion further? Those in favor? Say
Aye.
Aye. It carries. Thank you very much.
I have before we leave, I have a quick question. The document I'm looking at shows John G. Hudson, Hutson, and a Sherry Hudson, Hudson. Is that a typo?
I believe it is, yes.
All right, which is it? Hudson or Hudson?
It's HUD, but Hudson.
Hudson, Hudson. Okay, let's get that corrected then.
No, is it Hudson? You guys are muted.
Yeah, it's Hutson is how it's printed on my document.
It's T.
It's T. T as in Tom?
T, yes, sir. Yes,
So
it is.
Sherry Hudson is also T as in Tom?
Yes, sir.
Okay, we get that fixed. Minor point.
Okay. Thank you.
Oh, it's our understanding that we will receive a violation in our file for this event.
That is correct.
Yes. The short answer is yes.
Crazy times. Okay, thank you. I don't know what else to say.
Mr. Chairman,
Yes,
is that our last case?
that is our last case.
All right, if I can, for everybody who's still tuned in, this is Harry Blumenthal, and the chairman and the commissioners have debated how to enforce the COVID-19 violations. And so the public generally knows these are not the only violations that took place for the dates in question. Other violations have taken place, but the board thought because of the unusual nature of violating an executive order, which the board has been asked and actually by law must enforce, that we created a one-time opportunity, and many licensed premises have accepted use of that opportunity, which is to plead guilty, pay a fine of $500, and no public hearing process was necessary. So there are many more violations that took place on the dates of these other violations, but the public may not know about them because there was no need to publicize them. Secondly, the board struggles with, as council have found, how to logically and fairly interpret enforcement of the executive orders, which also change from time to time with very little notice. And it's the board's position and chairman's position and both commissioners that we are not the world's policemen. We have jurisdiction only over the licensed establishment and its employees. So if our inspectors find that violation occurred as a result of the public coming in and doing something that the licensee had no opportunity to correct before it happened, but somebody was there to see it, such as proper observance of 5 people at a table. There's no question that it's 6, spatial separation, and somebody else comes there and sits down. If that were the testimony, then the commissioners believe that they have to adjudicate whether or not a violation actually took place because the licensees did not make that violation occur. And lastly, council have conferred with me about the constitutionality of some of the executive orders of both the governor and the county executive. It's the board's position that it must enforce the law as it has been enacted by the Anne Arundel County Code and by executive orders of both County Executive Pittman and Governor Hogan. And we are forcing the laws as constitutional unless it is brought to our attention that on their face, there are court cases that say some portion or all of those orders are unconstitutional. A court may yet determine them as unconstitutional. It's up to council or the licensees themselves to raise the issue at a public hearing. Court cases have said that, in which to order to protect the issue for further appeal. But the board will deny summarily such objections, although it doesn't mind that they be raised, because, as I said, the board has to enforce the law as it is written, not as it perhaps should be written, and says unless a judge or judges declare otherwise. And those are the issues with which this board has struggled. And because this is the first case in which COVID-19 issues have arisen, the chairman has asked me to make that statement into the record so that licensees and the public are aware of the concerns of the board and the board's approach to it at this time. Mr. Chairman, thank you.
Thank you very much. Anything else?
I'm not quite sure what I heard Harry say. I'm going to talk about it a little bit. Are we saying that if people come in and exceed the table capacity, that it's not the licensee's fault? Is that what I'm hearing?
No, what I'm saying is that the board can take into consideration whether there actually was a violation of an executive order if the licensee did not cause the violation. If the licensee, for instance, in one case we've heard, has tables separated no more from each other, no more than 6 people, no more than 5 people at a table, and people come in, and before the licensee can react, somebody pulls a 6th chair up to that table, or a licensee comes in and inadvertently because he or she or they or not a licensee, a patron, just don't like an executive order and go out of their way to violate it before the licensee can stop the violation. That certainly is something that a licensee can use to contest whether or not the licensee itself violated the order or allowed its employees to violate the order. If, for instance, the licensee's employees are not wearing masks, corrected, that's a no-brainer. That's the licensee's fault. If the licensees conduct their business in a manner which the board finds conducive to a violation and a violation occurs, strict liability, and even forgetting the constitutionality of an executive order, the commissioners can make a finding that the licensees did not create the violation. It was created outside of their authority because they didn't have time to react. For instance, if one of our inspectors arrives at the scene, sits down, and sees somebody pull up a chair to a table of 5, that's one thing. If, however, 6 people are seated at that table and served by the licensee's employees, that's another thing. The executive orders are designed to protect the public, but the board only has jurisdiction over the actions of the licensees when on sting operations. If a licensee allows its employees to come and buy alcoholic beverages and doesn't take the proper means to inspect whether or not the person buying the alcoholic beverage meets the legal age, that's strict liability, and that's the board's licensee and the board's problem. On the other hand, there are some circumstances, which I won't go into, in which the factual backdrop may suggest that the licensee did not have time to react and were, I don't want to use these words with impunity, set off by a competitor or somebody, if it's a saying or not. And so it's got to be an action of the licensee because we are not the policeman for the world. If there's a problem that is more in the health department area, then the health department has to step up and either testify at one of our hearings or the states themselves maintain criminal jurisdiction over violation of the alcoholic beverage license provisions in the code. And that's because any violation of the state or county code of regulations by law is a violation of the Board of License Commissioners. So I'll point that out. These are issues with which all commissioners, all 3 of them, have had extensive discussion between themselves and with me as their counsel. And we want the public to understand that this is not something that we take lightly, but by the same token, we only have jurisdiction over the acts of people who are licensees. If something occurs, which clearly from the testimony was not the action of the licensees, then if the licensees had done something, that could constitute a violation. But if it's clear that something that could be a violation was not committed by the licensee, as I say, somebody walks up to a table and sits down and runs up, and an inspector is there, the board may or may not find that a violation existed, but at least it has the opportunity to do so.
Mr. Blumenthal, if I could, correct me if I'm wrong, but if I could provide an illustration of one specific aspect of the executive orders that might be helpful for Commissioner Filkins and others. There is a requirement in the executive order that patrons be seated when they're at the bar, that they not be served unless they're seated. Because the jurisdiction over these licensees is as a result of them being licensees and their requirement to protect the public welfare and follow the executive order, the board's decision about whether a violation has happened could be based upon whether or not the you'll have to interpret the executive order and what it requires of the licensees for their obligations of their license. So in my example, if someone were served while seated and then stood up, but the restaurant owners hadn't had a reasonable opportunity to ask that person to be seated, the very fact they might be standing wouldn't necessitate a finding of a violation of the public welfare obligation of the licensee. The board could find that that is not necessarily a violation unless the action of the licensee allowed that violation of the executive order to continue. So this is a challenge to enforce an executive order like this. It's really about public health and safety under an unprecedented pandemic. But I think that's what Mr. Blumenthal is getting at, is that some of these, violations may require commissioners to hear testimony from licensees or respondents who fairly point out that they were doing their part to enforce the executive order. And if the board could, if it chose, find that they had not committed a violation of the obligations of their license if the violation had not been caused by their inaction. And second, Mr. Blumenthal, I believe, referring to the 6-person limit at tables. And so if we just add +1 to the illustrations he was giving, I think that's what he intended. But correct me if Blumenthal is wrong, if I'm wrong about that.
No, that's a correct example. A correct example of strict licensee is that if face masks are not being worn by employees of the licensee, the public didn't make that happen. The licensee either let it happen or were negligent. But I just point out to the members of the public, just because one might read about violations in the media, they may not constitute a violation of which is punishable within the jurisdiction of the Board of License Commissioners. This is not as easy a proposition to adjudicate as one might first suspect. And I wanted the public generally to know that the chairman and the other two commissioners have had extended discussions about how to fairly interpret violations when they're brought to our attention by our own inspectors or others. And that's the way that we proceeded. We think it's a very serious situation because we are helping to protect the public from itself, quite frankly. Thank you, Mr. Chairman.
Thank you, Mr. Rosenblum. Mr. Blumenthal, what am I thinking? Long day. Anyway, does anybody have anything else to offer at this point? Okay, I call the hearing adjourned. Everybody,
Thank you.
good night.
Thank you all.
Thank you. And a fine day it was.
Thank you.
All right, take care of yourself.
Thank you.
Welcome, Mr.
Be
Davis.
safe.
Take care.